Less than a day after a federal judge ordered them to do it, the former president's two top White House lawyers went back before a Washington grand jury. This former deputy White House counsel Patrick Philbin arriving at lunchtime. His former boss, Pat Cipollone, testified earlier. Both men following up on prior testimony during which they declined to answer certain questions, citing the former president's claims of executive and attorney-client privilege. Now, meantime, the House January 6th committee met today. Among some of the other items left to decide whether to refer criminal charges against the former president or others to the Department of Justice. Sarah Murray's been doing the reporting on this. She joins us now. So do we know anything about Pat Cipollone's appearance before the grand jury today?
Well, Anderson, what's clear by the fact that they are returning is that what prosecutors want is more information about conversations that these two men had with former President Trump directly and advice they gave him. You know, obviously, we don't know exactly what they told the grand jury. Those proceedings are secret, but we know these are people who were in close proximity to Donald Trump in the final days and the aftermath. You know, when he lost the presidency, we know Cipollone pushed back on a number of efforts Trump was making to try to overturn the election. We know he and Philbin both pushed back when Donald Trump talked about replacing the attorney general with someone who was open to pursuing these bogus claims of election fraud. So obviously they have a lot of information, a lot of front row insights that prosecutors want as they delve into efforts to subvert this peaceful transition of power.
The House January 6th committee is expected to wrap up the investigation, deliver a final report. What's exactly left to finalize?
Well, you know, they know it is crunch time and they have a lot left to finalize. They have to sort of dot the I's and cross the T's on their final report. They're talking about how they really need to get this off to the printer, but they haven't done that yet. They need to make a decision on criminal referrals. We have heard them talk about this over and over again about how it could send such a powerful signal, even though DOJ is certainly not taking cues from the committee. They feel like it could send a powerful signal about their work. They still haven't made final decisions about criminal referrals. They said they hope to announce those in the coming days. You know, they also have to decide what they want to do about Republican lawmakers, people like Kevin McCarthy, people like Jim Jordan, who snubbed the committee subpoenas. Do they want to refer them to the Ethics Committee? Do they want to try to hold them in contempt of Congress? Or do they just want to do nothing because Republicans are going to take control in January? They have a couple more weeks to make these decisions. And again, you can tell in every conversation with them that they know they are going down to the wire.
Yeah, Sarah Murray, appreciate it. Thank you. More now on all of that, as well as the 11th Circuit Court of Appeals are returning the court-appointed special master in the Mar-a-Lago documents case and the rebuke it contained to the federal judge who ordered it. CNN contributor and former Nixon White House counsel John Dean joins us now, along with retired federal judge Nancy Gertner, who's currently a senior lecturer at Harvard Law School. John, how much more jeopardy, in your opinion, could the former president be in now that Pat Cipollone and Patrick Philbin have appeared before the federal grand jury? I mean, is there anything that would change in their willingness to talk about things they hadn't been willing to talk about before because of presidential privilege?
I think what they were doing, Anderson, is waiting for a judge to order them to speak. They had a commitment under the attorney-client executive privilege. They could have decided we're not going to honor that, but the attorney-client they don't throw off quite as easily. So what the grand jury got was a lot of firsthand information about what they had told the president and the president's reaction thereto, to all the things Sarah nicely summarized. And that's a lot of information that the grand jury did not have. So this, to me, would increase Mr. Trump's jeopardy considerably.
So just to be clear, John, you think that because the judge ruled in this and sent them back to testify, that they would say things that, for instance, they wouldn't say to the January 6th committee because of executive privilege?
Absolutely. That's right. And that nails it.
Judge Gertner, on the Mar-a-Lago documents case, were you surprised at the ruling at all?
No, I wasn't surprised. I mean, to some degree, Trump's lawyers have been able to play out this string, and because you are journalists and you want to give due to what they were filing documents which, to anybody who knew anything made no sense. The notion that any criminal defendant after a search can go into court and say, stop the presses here. I want to look at all the documents. Give me back the documents. I want to see whether you seized things that you shouldn't have seized. The notion that any criminal defendant, well, let me actually change that. Anybody whose house was searched before they were indicted had rights to control the investigation is absurd. There are certainly attorney-client privileges. Law firms get special masters, but no one had ever been treated this way. And if the former president says that, he's treated worse because he's a former president and he's Trump, it's actually the reverse. These arguments were considered and dignified, And the 11th Circuit finally said, as the district court judge should have said, enough. This is absurd.
And Judge, I understand you've given some consideration to where charges might ultimately be brought against the former president. I mean, there's Palm Beach, that's where Mar-a-Lago is located, or in D.C., where he removed the documents from, or where the documents were removed from.
Well, that's actually going to be a complicated question, and I don't think we have all the facts to answer it. So on the surface here, there was clearly illegal retention of national defense information and documents that didn't belong to him after he left the presidency. That retention, the withholding of that, the concealing of that, takes place in Mar-a-Lago. But the taking of the documents started in D.C., but arguably started when he was still president and had a right to these documents. The testimony of Pat Cipollone and others might help understand whether there was a conspiracy to illegally retain the documents that began in the District of Columbia. If that's so, then the charges can be brought in the District of Columbia, which, the one thing that we know for certain, by the way, is that even if the charges were brought in Palm Beach, I don't think Judge Cannon would be sitting on this case. But the 11th Circuit slapped down, essentially saying you had no jurisdiction to do what you're doing, I think should foreclose her sitting on this case in the future.
Who decides something like that, though? I mean,
well, it would go if let's say the venue issue is something that the Department of Justice has to decide. What were the acts that were committed?
no, but who
where?
decides? I mean, if it does go to, in Florida, who would make the decision? Well, the judge who made this inappropriate ruling before shouldn't get the case.
Well, if the kid, what happens is it goes into the draw. It goes into essentially a lottery. And if she wound up getting the case again, there would certainly be motions to disqualify her. And then the chief judge of the circuit could weigh in and say, you should be disqualified. Unlike the Supreme Court, I have to say this, there are ethics rules that apply to the district court and are actually enforced.
So, John, with the January 6th committee, do you think, there's the question of whether they will, submit something to the Department of Justice about prosecution. I mean, they don't need to. It's not like the DOJ is waiting around for a referral from the January 6th committee. Do you think their final report is going to focus on the former president himself as opposed to the totality of the events of that day?
I think that is the case. Certainly, there was some rumbling that the staff was unhappy about the focus of the final report, that it did focus on Trump too much. But on this issue of referral, there's probably a pretty good consensus that they will make referral. And the reason I think that's the case is because they've got overwhelming evidence, and it will be more than Donald Trump. It'll be other players that we've heard less about that they will make those referrals. Now, justice doesn't have to, they can totally ignore that information, but what it does, it affects the public perception of the case. And I think that could put a little wind behind the sail of the department if they make referrals, and it'll educate the public as well.
Well, Judge, the flip side of that is, do you think the Department of Justice wants to get a criminal referral from the January 6th committee just in terms of the optics of it? Could it give a whiff of politics to something that Merrick Garland is trying to keep apolitical?
Well, on the one hand, it could give a whiff of politics. On the other hand, the January 6th report, if it's anything like the live testimony, will tell a much more complete narrative than the Department of Justice is able to tell in the confines of a formal indictment. They can say much more. And
they can tell the story, essentially.
They can tell the story, and as they really have, in sort of the way journalists tell the story. The legal proceedings are much more structured and much more formal. So, on the one hand, that story may be one the Department of Justice wants to see out there.
Yeah.
But yes, it gives a whiff of politics. But frankly, at this point, that's unavoidable. Just unavoidable.
Nancy Gertner, John Dean, appreciate it. Thank you.